If you've been paying attention to the news, protests are in, and in a big way. Have you ever wondered how far you can go in expressing your beliefs through protest without breaking the law? What are the boundaries between passionately advocating for change and stepping into illegal territory? Today, we're diving deep back into the First Amendment to explore exactly where those lines are drawn. Whether you're rallying for racial justice, marching for gun rights, or standing up for any cause you believe in, understanding these rules can protect your freedom. Stay with me, because we're going to look at iconic historical protests that reshaped America, and then we'll unpack Supreme Court decisions, and by the end we'll work through 5 rules so you know exactly how to exercise your right to protest safely, confidently, and patriotically. Because the freedom to speak out isn't just important, it's a cornerstone of our American democracy. America's story has been written in part by patriotic protests. We, the people, have often taken to the streets to demand a more perfect union. In the 1960s, for example, civil rights demonstrations, from the Montgomery bus boycott to the March on Washington, awakened the nation's conscience. These peaceful protests led directly to landmark laws like the Civil Rights Act of 1964 and the Voting Rights Act of 1965, dismantling segregation and securing voting rights. In the early 1900s, women suffragists also proved the power of protest. In 1917, women stood day after day outside the White House with banners declaring, "Mr. President, how long must we wait for liberty?" They endured jeers, jailing, even forced feedings when they went on hunger strikes. Their sacrifice paid off. President Woodrow Wilson and Congress were eventually moved to approve the 19th Amendment, and in 1920, American women won the right to vote. Even in more recent history, the Supreme Court has stepped in to uphold the proud tradition of peaceful protest. A pivotal case was NAACP versus Claiborne Hardware in 1982. The case sprang from events in the 1960s civil rights era when black residents of Claiborne County, Mississippi, organized a boycott of white-owned businesses to protest racial injustice. The NAACP led the boycott, and some individuals made threats against black citizens who didn't join the cause. Local store owners sued for financial losses, and state courts initially ruled that the entire protest and all 92 NAACP defendants were liable for damages, essentially punishing the whole group for the unlawful acts of a few. The Supreme Court unanimously reversed that decision, delivering a resounding affirmation of First Amendment protections. The court held that peaceful political boycotts are a form of constitutionally protected expression. Simply supporting a protest or boycott cannot make someone automatically liable for others' misconduct. To hold someone responsible, the court said, you need clear proof that they intended and incited any unlawful actions. In other words, the state can't punish an entire movement for the misdeeds of a few bad actors. It's hard to overstate how important Claiborne Hardware is for protest rights. As a constitutional litigator, it's actually one of my go-to cases in my toolkit of important First Amendment law. By protecting even a nonviolent boycott, even one that caused economic harm to businesses, the court affirmed that the First Amendment covers more than spoken or written words. And critically, the government can't convict and others can't sue you just for belonging to a protest group unless they prove you intended to further some unlawful aim. Another landmark case testing protest rights was Snyder v. Phelps in 2011. The case dealt with extremely controversial and hurtful speech, yet it demonstrated the depth of America's commitment to free expression. It involved members of the Westboro Baptist Church who protested near the funeral of Marine Matthew Snyder, displaying signs with messages like, "Thank God for dead soldiers" and "God hates fags." The fallen Marine's father was deeply anguished by this display and sued the protesters. The question reached the Supreme Court. Can the First Amendment shield protesters who inflict such pain on private citizens? In an 8-1 decision, the court said, yes, it can, because the protesters' speech was on matters of public concern and took place in a public forum. Chief Justice John Roberts, writing for the majority, acknowledged that the signs were deeply offensive and hurtful, but he explained that the First Amendment's core purpose is to protect debate on public issues, which should be uninhibited, robust, and wide open. In stirring language, the decision affirmed that the First Amendment sometimes protects expression that we hate to ensure that no government can silence speech simply for being unpopular or upsetting. I want to pause, and I hope you're enjoying this content, because so much of what I produce isn't what legacy media wants you to hear. Clean, crisp, no-nonsense explanations of your key freedoms. So that makes it hard for this channel to be recognized by YouTube, and I'm counting on you to help me break through that wall of monotony by liking and subscribing to this channel. It's an easy thing to do, and it really helps with my efforts. Now let's get back at it. With these cases in mind, how do we tell what kinds of protest actions are protected by the First Amendment versus those that cross into the line of unprotected conduct? Over the years, courts have developed several key principles to answer that question. Rule number 1, the do no harm principle. The First Amendment protects peaceful assemblies and expressive conduct, but it does not protect violence, vandalism, or rioting. You have the right to march, to chant, to hold signs, and voice your demands even loudly. That's classic protected speech. But if a protester starts throwing rocks through windows, setting fires, or physically attacking people, those criminal acts can be prosecuted. The distinction is simple. Speech is protected, violence is not. Our law encourages passionate advocacy, but insists we channel it through nonviolent means. Rule number 2, no incitement. Speech that intentionally incites immediate violence or law-breaking is never protected. The Supreme Court standard established in Brandenburg v. Ohio and echoed in the Claiborne Hardware case says that government can punish speech that is directed at inciting imminent lawless action and is likely to produce such action. What does that mean? If someone at a rally is actively egging the crowd on to commit violence right now or soon, and it's likely the crowd will do that, that speech can be stopped or punished. For example, a protest leader shouting, "Let's storm the building and burn it down," would be incitement outside of First Amendment protection. But short of that high bar, even hateful speech like "all congressmen should die" is protected. The courts have been careful here. They don't want to punish fiery rhetoric, passionate opinions, only speech that is a real-time trigger for a riot or lawless action. Rule number 3, no true threats. The First Amendment doesn't protect true threats, which are statements where the speaker means to communicate a serious intent to commit violence against a particular person or group. You cannot claim free speech as a defense if you stand outside someone's door and threaten to kill them, for instance. In the protest context, this means you cannot threaten specific people with harm or death. A political sign or chant, no matter how harsh, is generally okay if it's expressing an opinion. Down with politician X, or we'll remember in November. But if it crosses into a direct, credible threat, shoot Congressman Jones, directed at the person, for example, it loses protection. Likewise, intimidation tactics like burning a cross on someone's lawn, as was the case in Virginia v. Black, 2003, where cross burning was intended to threaten, that's not shielded by the First Amendment. The line can sometimes be fine, and you need skilled lawyers in those cases. But the overarching rule is advocacy is protected, actual threats are not. Rule number 4, time, place, and manner rules. Even protected protest speech can be subject to certain neutral regulations on when, where, and how it's delivered, as long as those rules are content neutral and serve an important public interest. For example, a city can require a permit for a large march that would block traffic on Main Street to ensure ambulances and commuters can still get through. They might limit the noise level at night in residential areas, so a protest can be required to end by 10 p.m. or keep bullhorn volumes down to let neighbors sleep. However, any such restriction must be even-handed. Authorities can't discriminate based on viewpoint. They can't say only pro-choice rallies must get permits, for instance, or ban gun right demonstrations, but allow gun safety demonstrations. Courts also insist that alternative channels for speech remain open. You might not march down Main Street without a permit, but you could march on Side Street or protest in a park. So while you absolutely have a right to protest, you might not have a right to do it anytime, anywhere, anyhow, without regard to public order. Rule number 5, no civil disobedience without consequences. It's worth noting that if protesters intentionally break certain laws as an act of civil disobedience, they may still face consequences. For instance, trespassing on closed government property, blocking traffic on a major highway without a permit, sound familiar? Or chaining oneself to a piece of machinery. These are classic civil disobedience tactics, but they're not fully protected. The protest message itself is protected, but the law can still punish the specific unlawful conduct. Many civil rights activists in the 60s accepted arrest as part of their strategy. The key point, having a political motive doesn't create blanket immunity from laws of general applicability. In some, when protest stays within the realm of expression, signs, speeches, marches, symbolic acts, it's highly protected. But when it crosses into direct law breaking, violence, threats, or dangerous illegal conduct, it can be curtailed or punished. Let's apply these principles to a real-world example of a recent liberal-leaning protest movement, the Black Lives Matter demonstrations, that were against racial injustice and police brutality. In the summer of 2020, loads of Americans took to the streets in cities and towns nationwide. These protests were overwhelmingly peaceful. The marches had signs saying "Justice for George Floyd" or chants of "Black Lives Matter." And this is core political speech, exactly what the First Amendment exists to protect. But we also remember that some protests in 2020 did devolve into rioting and clashes. If an individual at an otherwise lawful protest starts looting stores, throwing objects at police, or setting cars on fire, the person is no longer shielded by the First Amendment. Those are criminal acts, not expressive speech, and they can rightly be prosecuted. What about situations where a protest leader is blamed for others' violence? This issue arose in a 2016 BLM protest in Louisiana, where a police officer was injured by someone in the crowd and tried to sue the organizer, DeRay McKennison. In a win for protest rights, courts ultimately ruled that a protest organizer cannot be held liable for the unintended, unlawful actions of others unless the organizer purposefully incited the violence. In other words, just leading a protest isn't a crime. Now consider a conservative-leaning protest issue, such as rallies in support of Second Amendment gun rights. The First Amendment protections apply equally here. Americans who lean right have used their protests to voice their views just as energetically as those on the left, and their speech is just as protected. For instance, on January 20, 2020, thousands of gun right advocates gathered in Richmond, Virginia, for a huge rally opposing proposed state gun control laws. It was a striking scene. Many protesters openly carried rifles and handguns, legal under Virginia law, chanted "USA, USA," and other slogans in support of the Second Amendment. There were legitimate concerns beforehand that such a volatile issue and the presence of firearms might lead to trouble. But in reality, the Richmond gun rally remained entirely peaceful. An estimated 22,000 people demonstrated without any violence or major incidents. Protesters followed the rules. The governor had temporarily banned guns on Capitol grounds, and attendees complied by staying armed only in the areas where it was permitted. This example underscores that even the right to protest covers very contentious, emotional issues on either end of the political spectrum. Gun enthusiasts voicing opposition to new laws, carrying signs that say "Don't tread on me," or sporting their firearms in a show of symbolic speech, that's protected activity as long as it stays peaceful. Some viewers might have felt intimidated seeing a crowd of armed protesters, but being alarming or provocative is not illegal. The test is action, and here the actions, chanting, lobbying legislators, rallying on public streets, were all lawful acts. No matter one's politics, we should appreciate that our Constitution lets people air their grievances freely, whether the cause is gun rights, tax reform, religious freedom, or anything else. Of course, the same line drawing applies. If a hypothetical gun rights rally were to cross over into threatening violence, it would lose protection. Imagine if some radicals at a protest started urging others to take up arms and attack public officials. That would likely qualify as incitement or true threats, which authorities could act against. Or consider a real-life event. that tested the boundary. On January 6, 2021, thousands of Americans rallied in D.C. to protest the certification of presidential election results. The rally itself, featuring passionate speeches and chants, was protected First Amendment activity. Indeed, I successfully defended a famous speaker at one of the January 6th events who gave a perfectly innocuous speech but was sued as being party to some unknown conspiracy. The concept's pretty simple. People have every right to assemble and voice dissent against government action, even if their claims are controversial. However, when a small portion of that crowd marched to the U.S. Capitol and forcibly breached police lines and entered the building, smashing windows, halting Congress's proceedings, it ceased to be a lawful protest and became a criminal riot for those people. The lesson from both liberal and conservative protest scenarios is the same. So long as you keep your protests peaceful and within the law, your rights protect you, regardless of your ideology. Whether you're shouting for climate action or gun rights, racial justice or religious liberty, the Constitution has your back. But if you step over the line into coercion, into violence, the law can step in. And that balance is what keeps our society both free and orderly. Every American, whether on the left, right, or center, has a stake in preserving the First Amendment right to protest. It's one of our nation's proudest traditions and a cornerstone of our democracy. Freedom of speech and assembly is truly the great equalizer. It is the power of the powerless and holds the powerful accountable. We've seen throughout history that today's protest movements can lead to tomorrow's legislation and real social change. The civil rights movement, women's suffrage, Vietnam War protests, anti-COVID lockdown rallies, and marriage equality marches. Different causes from different eras, but from different perspectives, yet all quintessentially American in their reliance on the freedom to be heard. In that sense, we should all be united by the right to protest. Patriotism isn't just flag waving, sometimes it's speaking out to demand America live up to its ideals. When citizens protest, it's often because they believe in America's promise and want to make it better. That is a profoundly patriotic act. The image of Americans of all colors, creeds, and convictions gathering peaceably to petition for redress of grievances is as patriotic as the Star-Spangled Banner. It shows faith in our system, faith that if we raise our voices, our leaders and fellow citizens will listen. And time again, that faith has been rewarded with progress. That's pretty amazing. As we conclude, let's reaffirm this. The right to protest is a birthright of every American. It's enshrined in the very First Amendment of our Bill of Rights, alongside freedom of religion, press, and freedom of speech. It belongs equally to the least of us and the most powerful among us. It belongs to you, me, and the neighbor down the street whose opinion we might find baffling. Protecting this right for others, even when we disagree, protects it for ourselves. It creates a society where change can come about, not through bullets or bayonets, but through arguments and appeals to conscience. I'm Benjamin Barr, and I'm thrilled you joined us today. My job is to give you the tools necessary to solve today's constitutional puzzles. Be sure to join us next week when we tackle yet another constitutional controversy.